The following BLTV program is brought to you by O'Flaherty Law. Please enjoy.
I'm a Wisconsin attorney with O'Flaherty Law, and today I'd like to do a how-to video on how to complete Form GN-3290, the petition for either temporary or permanent guardianship in a minor guardianship of the estate. I have the form pulled up here on the screen. As you can see at the top of the form, it says State of Wisconsin Circuit Court. Then you would enter the name of the county that you are filing the petition in. This is the caption. It will read, in the matter of, you would put the name of the minor, their date of birth. And if this is your first petition and there's no case number, don't worry. When you file the petition, the court will assign a case number to your matter. However, if you come back later and have to do an amended petition, you would need to enter the case number that was assigned to your matter. Looking at the title, you can see that this is a petition for either temporary or permanent guardianship, minor guardianship of the estate. So you're not asking for guardianship over a person. You are asking for guardianship over their finances and their assets. And we'll talk a little bit more later on in the application whether you're asking for temporary or permanent guardianship. Over here to the right of the page, you'll see a blank spot. That's for the court clerk. That's where they'll file stamp the document and put any other notations that are necessary to keep track of your matter. So don't put anything there. So it begins with, I state in paragraph 1, I am interested as a relative, a public official, or other. So a relative, you would just state your relationship to the minor. A public official, you would explain what your authority to act as a petitioner is. And then if there's some other relationship that's not listed above that explains why you're interested in this and you're filing a petition, here's where you would click and explain to the court how you're interested in this situation. So paragraph number 2, this petition is filed in the county in which minor either resides or is physically present. If there's an unusual set of circumstances that requires that you file outside of a county that the minor resides or is physically present in, you would click Other and explain that to the court here. In paragraph 3, you tell the court where the minor lives. Typically, it's within the state of Wisconsin, and the minor will have a mailing address within the state of Wisconsin. However, if you've explained in paragraph 2 that the minor is not physically present here and explain why, then you would just put where the minor is living. And it could be in another state. Sometimes when you petition for guardianship of an estate, it is in conjunction with petitioning for the guardianship of the person. The minor might be in a facility either for medical care or caring for their basic needs, depending on the facts and circumstances of the minor's situation. An example would be if the child had been seriously injured due to abuse by the child's parents or guardian, they could be in a hospital. And if they're currently staying in a hospital or nursing facility, you would tell the court that's where they are. Another possibility would be that the child's parents or remaining parent passed away and there was no one to take the child immediately, so they put the child in perhaps temporary foster care until relatives could be alerted and begin the process of getting guardianship. In that case, you would name whatever foster care facility the child was in, their phone number and address. Question number 5, we'll ask you if the minor has been previously adopted. Pretty standard yes or no question. Paragraph number 6 wants to know the names and mailing addresses of all interested parties, including you, the person who's filling out the petition, and all others entitled to notice. So they don't give you a lot of room here. You can always put this information, the names, relationships, and addresses of interested parties on a separate sheet of paper and then click See Attached and attach that paper to your petition. Some examples of interested parties would of course be living family members, very close friends of the family. If the child is the member of an indigenous tribe, the tribe would need to be notified. If there are pending matters where the child has been assigned by the court a guardian ad litem or adversary counsel, those attorneys would be considered interested parties and they would need to be noticed upon the filing of the petition. So as you can see, it could be a very long list. Paragraph 7 really only applies if the minor is married. If the minor is married, does the minor have children who are not of the current marriage? So let's say the minor had a child when they were 15, and then later on when they were 17, the minor married someone who was not the natural parent of a child. You would need to clarify that for the court. If the minor has children, the court needs to know all the children that the minor has. Paragraph 8. This is a situation where you're probably going to want to have another attachment, even though it doesn't give you a See Attached option. You could just put See Attachment and explain the situation on a separate sheet of paper. The whole point of it is that this petition is made in the best interests of the minor, and the minor needs a guardian of the estate because obviously it's probably going to be more than one line of explanation here. This is where you lay out the specific facts and circumstances that have led to the minor needing a guardian of the estate. And you would also need to explain why having one appointed would be in the best interests of the minor. Paragraph 9 is where you explain to the court whether or not you are aware of any other guardianship of the estate or related proceeding or ordered proceeding involving the minor in another state or country. So, for example, the child could have relatives in the state of California and they could be filing for guardianship over the child and their estate in California. If you're aware of that, you need to tell the Wisconsin court about it. If you're not aware, you just tell the truth and say, I don't know. If there is another proceeding or even another guardian appointed within or without the state of Wisconsin, you need to give all that information that you have to the court. And of course, if this is too small of a space, you can do an attachment. Moving on to paragraph 10. So even if you are petitioning for appointment of a guardian of estate does not necessarily mean that you are asking for the job. You can nominate a proposed guardian of the estate. If you're asking for temporary guardianship, you can nominate a temporary guardian, and you can also do a backup or standby guardian. Now, again, this is a small area to fill in with information, so you can always click See Attached and list your nominees on a separate piece of paper, where they are, how to get in touch with them. This is a trickier, more sensitive question. If one or both of the parents are still alive, the court is going to ask why they can't be in charge of their child's finances. So again, if you're not nominating one of their parents, you have to click on this and explain why to the court. Typically, this would be more than a one-sentence answer, and although they do not give you a See Attached option, you can always just write See Attached on the line and then attach your explanation to the petition. When you file petitions with the court, a great deal of the time, the court doesn't just want the petition, they want additional documents. Paragraph 11 explains one additional document that is absolutely required when you are filing a petition for guardianship of estate. a sworn and notarized statement of acts by proposed guardian of the estate and consent to serve. So this would be a statement of what the proposed guardian would propose to do with the estate and their consent to serve as the guardian, because it's not a fun job being in charge of someone else's money and being responsible for it. So a sworn and notarized statement of acts and consent would need to be prepared, and it either needs to accompany the petition when you file it. It should be filed within 96 hours before the hearing that will be scheduled on your petition. Or you can also say will be provided if required by the court for the temporary guardianship of the estate. So if you're asking for temporary guardianship, you can just click that if the court wants it, you'll provide one. Paragraph 12 is where you list the value of whatever the minor's property is. This can be very considerable. They do allow you to attach a document you create listing the general description and amounts of the minor's property. They do divide it up into cash/bank accounts, real estate, and other liquid assets. And then, of course, you can always list anything else that is of value that belongs to the minor. You also need to clarify if the assets of the minor previously derived from, or if there are benefits of the minor now due and payable from the United States Department of Veterans Affairs. And of course, if there's none, that's easy. You just click none. And if there are some, then you need to list them. And of course, you can do it in a separate document because sometimes these can be considerable. You also need to list whether or not the minor receives public benefits, and that includes medical assistance, Social Security income, Social Security disability income, or long-term community options program benefits. If there's none, just say none. If there's yes, go ahead and list them, and you can do an attached document. Then number D is kind of a catch-all again. Any other claim, income, compensation, pension, insurance, or allowance to which the minor may be entitled is either none or as follows. If they receive additional Social Security, they could be getting Social Security payments for more than one person. If they're receiving child support, if they're receiving disability payments, if they're receiving dividends from an investment. And then, of course, there's other. So there's a catch-all there, and you can always put it on a separate sheet of paper. It's important to be as thorough as possible because if you plan to be the guardian of the estate or your nominated guardian of the estate steps up, they're going to want a complete financial picture of the assets and accounts that they have agreed to oversee on behalf of the minor. Paragraph 13, if the parents are still alive, you have the option to ask the court order child support. Typically, it's determined on the amount of income one or both of the parents earns. It's important to ask for it if it's at all possible. If the parents aren't alive and there's no one to pay child support, you don't have to click for it, but if the parents are still around, you should ask. Now, we're getting to permanent or temporary, which we discussed briefly earlier in the video. Permanent guardianship would be control over the minor's assets and finances until they turn 18. Temporary guardianship is more for an emergency or very specific situation. We'll go through permanent guardianship first. So if you're asking for permanent guardianship, you're asking for control over pretty much all of the minor's assets and finances until they're 18. So you click on this, you check permanent guardianship and guardian of the estate, and then you request that the court authorize the guardian to perform certain duties, to empower the guardian with certain abilities. And you just pick all three or just one or two, depending on your situation and what is required. So A, you would ask that you could be allowed to perform additional powers other than to make gifts that require court approval under State Statute 5420 sub 2, and you would list what you needed to be able to do as the guardian of the estate. Again, it's a small line. You can do it on a separate sheet of paper and just click See Attached. You can also ask the court to empower you to deposit the minor awards funds of $100,000 or less in an insured account of a bank, credit union, savings bank, or savings and loan association in the name of the guardian of the estate and the minor ward. However, it would only be payable upon further order of the court. So you're asking if you can put some money away for the ward. You can also ask that the court waive bond, which means that you would not be bonded. And then D is another catch-all, where if you believe you need additional power to perform certain duties in your guardianship of the minor's estate, you would explain what you needed to be able to do and why. And in situations like this, it's best to be as specific as possible and have a reason for every power that you're asking for. So I would probably put C attached and explain D, other, on a separate sheet of paper. So number 15 is if you want an alternative to guardianship of estate if it's a very small estate. The minor only has a little bit of money. The minor only owns one small property. Here you would ask, I request that the court dispense with the appointment of a guardian of the estate and transfer the minor's funds of $50,000 or less according to one of the alternatives for small estates under 5412 sub 1 as follows. You would explain what the asset is and you would explain where you wanted the asset to go and that you just want to keep things simple. And that's why it would be an alternative to guardianship of estate. And then again, you can always do a C attached and explain what the minor owns, what should be done with it until they turn 18. Hopefully something with minimal oversight that you wouldn't have to have a lot of powers as a guardian of the estate to oversee on the minor's behalf. So that's permanent guardianship of the estate. If you're asking for temporary guardianship of the estate, it's really a short-term, simpler, and more emergency type of guardianship, I guess, if you look at it that way. Paragraph 16 asks if there have been no temporary guardianship of the minor in effect within the last 90 days. So as long as you can answer that question with correct, you can move forward with requesting a temporary guardianship. Paragraph 17 explains further by saying that the minor's particular situation, including the needs of the minor's dependents, if any, requires immediate appointment of a temporary guardian for the following specific reasons. Now, it's really kind of tough to come up with some good emergency examples. The idea is that this is an emergency situation and the minor, for whatever reason, can't handle their financial situation and they need somebody else, somebody older, more experienced to step in and handle a specific financial issue for them. It's going to take more than one line to explain, so you would click the C attached and explain why you want that temporary guardianship on a separate piece of paper. In paragraph 18, you state that you petition the court for the appointment of a temporary guardian with authority limited to those acts that are reasonably related to the reasons for appointment. So again, this is a short-term emergency kind of situation. The guardian really only needs to be appointed to go in and do one or two things that turn on the specific facts and circumstances at hand. This is not a long-term situation. This is an emergency short-term situation where you need temporary, limited authority to handle a financial matter for the minor. So in paragraph 18, you would ask the court, or you would tell the court what authority you are requesting for the temporary guardian of the state. And again, it's usually more than one line's worth of information. Click See attached, put it on a separate sheet of paper. Explain as fully as possible, be as specific as possible as to what duties you believe you need to temporarily have the power to perform. So if you're asking for temporary guardianship, you do need to explain to the court if you are also asking for a permanent guardianship. If you are asking for a permanent guardianship at the same time, for long-term management of the estate, you would click on this. But if you're only asking for that temporary emergency guardianship of the estate, you would click and say that you are not filing one with the petition for the following reasons. It could be something like minor turns 18 in 30 days. Or this is just an emergency situation because the minor is incapacitated in some way and there's nobody else to help them. Something along those lines. Obviously, again, more than one line's worth of explanation would be needed. You click See Attach and explain it on a separate sheet of paper. 20 is kind of an overall catch-all. Any additional requests you want to make on the court now that you have their attention, including an expedited hearing. If you have something unusual that's not really covered in the form, or if you want to speed the process up, this is where you talk about it. This is where you ask for it. Finally, your formal request to the court. I request that the court, 1, order a hearing on this petition. 2, make appropriate findings and appointments as requested above. And 3, award appropriate fees and costs. Again, as always, there's our little other catch-all at the bottom where if you have an additional request to the court that's not listed here, you can click on that and explain what you'd like the court to do for you. At the bottom, you just have the standard signature block, sign, print, your name, fill out your address, your email, your telephone, and of course the date you signed it. So a final note, we've talked a lot about attachments in this video. At the bottom of every sheet of this form, it says this form shall not be modified. Do not try to get fancy and add lines to the actual form so that you can have everything typed up in one document. Use the separate sheet we talked about throughout this video. This is the supplemented with additional material that the form is talking about. Don't alter the form. And that is how you fill out a petition requesting either temporary or permanent guardianship of an estate in a minor guardianship. It's form GN 3290. I want to thank you so much for watching. To learn more about guardianship in Wisconsin, you can visit our page. It's linked below.
Hi again, this is Kevin O'Flaherty from O'Flaherty Law. I hope you enjoyed the video and podcast. If you did, I'd love it if you'd subscribe to our channel. If you need legal help in this or any other area of law, please don't hesitate to reach out to schedule a consultation. Most consultations are free and can be conducted remotely if you'd like. You can email us, book online, or call us at 414-253-2080. That's 414-253-2080. We have many locations for your convenience and we serve all of Wisconsin. Thanks again for watching.